Hello, my name is Tim Schnell. This presentation is being offered by the State Tax Commission and is intended to explain the MCL 211.154 process and the statutory authority for addressing omitted and incorrectly reported property. The State Tax Commission has the statutory authority to correct assessments in order to 1. Address the incorrect reporting of property by a taxpayer, and or 2. Add omitted real and personal property to the assessment roll. There are various situations in which the State Tax Commission does not have jurisdiction. The State Tax Commission cannot do the following. It cannot address a valuation issue, spread a change of taxes, in other words, a change in assessed or taxable value for a period prior to a change of ownership, change the classification of real or personal property, consider a taxpayer's request for a change to a personal property assessment that was estimated by the assessor because a personal property statement was not timely filed or was not accepted as filed, grant or remove a property tax exemption where the original treatment by the assessor required the exercise of his or her professional judgment, change a July or December Board of Review determination, which must instead be appealed to the Michigan Tax Tribunal, remove assessments of leasehold improvements which were assessed to a tenant as personal property, change an assessment for a tax year prior to the current assessment year and the two immediately preceding assessment years, reverse an uncapping of taxable value erroneously made by the assessor, enter a delayed uncapping of taxable value. In many cases where the State Tax Commission does not have jurisdiction, there are other potential remedies. These potential remedies include the following. Valuation and exemption disputes must in some cases be protested to the March Board of Review and may be appealed to the Michigan Tax Tribunal. Classification of real or personal property may be protested to the March Board of Review and appealed to the State Tax Commission by June 30th under a separate appeal procedure. If the assessor determines that he or she erroneously uncapped the taxable value of property, the uncapping may be reversed by the July or December Board of Review for the current year and up to the 3 immediately preceding years. If the property owner has not filed a property transfer affidavit, then the assessor may enter a delayed uncapping of taxable value. If the property owner filed a timely property transfer affidavit, but the assessor failed to uncap the taxable value, any March Board of Review may correct the taxable value prospectively. The State Tax Commission's jurisdiction under MCL 211.154 is limited to correcting assessments for the current assessment year, that is the year of discovery and disclosure to the Commission, and for the 2 immediately preceding years. Failure to file the petition with the State Tax Commission by December 31st of the year of the discovery may affect the Commission's jurisdiction to consider all of the years that have been included in the petition. The party seeking to correct the assessment must file a petition with the State Tax Commission requesting correction of the assessment and must also transmit a copy of the petition to the other interested parties. There are 3 different petition forms, and the form used will depend on who is filing the petition. An assessor or equalization director who files a petition does so on Treasury Form 627. A taxpayer or taxpayer's agent who files a petition does so on Treasury Form 628. And a third party who wishes to notify the State Tax Commission of incorrectly reported or omitted property does so on Treasury Form 629. There are supporting documents that are required to be filed by a petitioner along with the 211.154 petition in order for the petition to be reviewed. Those documents are, for real property, the petitioner must include the following: all property record cards and the calculations and documents that are needed to understand the reasons for and the amount of the requested changes in the assessments and taxable values. For personal property, The petitioner must include the following: copies of all filed personal property statements for the assessment years for which a correction is requested, corrected or taxpayer-filed amended personal property statements for the same years, copies of audit summaries supporting the requested change, if any, and the calculations and documents needed to understand the reason for and the amount of the requested changes in the assessments. A taxpayer should seek the assistance of the local assessor in computing the correct amounts if it is unclear as to how the computation should be made. The State Tax Commission believes that the assessor should provide such assistance even if the assessor disagrees with the taxpayer's requests. If a taxpayer is unable to obtain assistance from the assessor, limited assistance may be requested from the Property Services Division of the Michigan Department of Treasury by calling area code 517-335-6519. If all parties concur with the request contained in the petition and the Commission staff does not object, the matter will be presented to the State Tax Commission as a concurrence and an order will be issued. If a concurrence is not entered and/or if the Commission's staff objects, the matter will be scheduled for consideration at a State Tax Commission meeting. Interested parties will be notified of the date so that they may attend and be heard by the Commission. Attendance at the meeting in which the MCL 211.154 petition will be heard by the Commission is not required. However, if the State Tax Commission wishes to direct questions to an interested party who is not present, that party's absence may influence the decision made by the State Tax Commission. Following the conclusion of the meeting, copies of the State Tax Commission's order will be sent to the municipal treasurer who has custody of the tax roll for each assessment year in question. If appropriate, an amended tax bill and/or refund will typically be issued within approximately 30 days. Questions concerning refunds should be directed to the county or local treasurer who has possession of the tax roll which has been corrected. The State Tax Commission provides information regarding the MCL 211.154 petition process. The information can be located at www.michigan.gov/154petitions and includes the status of a 154 petition or order, the date and time the petition is scheduled before the Commission, any action taken by the Commission, hyperlinks to petition forms, State Tax Commission meeting schedules and agendas, the 154 petition orders, the General Property Tax Act, Public Act 206 of 1893, which includes MCL 211.154, the State Tax Commission rules relating to the Section 154 petition process. Note, forms and copies of already entered orders can be viewed and printed from this site. The State Tax Commission will not fax copies of orders. A taxpayer generally has a right to appeal the decision made by the State Tax Commission to the Michigan Tax Tribunal within 35 days of the date that the Commission's order is issued. For additional information, please visit the State Tax Commission's website or contact the Office of the State Tax Commission directly. The State Tax Commission hopes that assessors and taxpayers will find this 5-minute series video regarding the MCL 211.154 process and the statutory authority for omitted and incorrectly reported property to be a valuable tool. Thank you.